Good morning, Mr. Maidman.
Good morning, Justice Marshall. If it pleases the Court, I'd like to address the motion for required finding of not guilty issue first. In this case, the defendant was convicted of being a joint venturer in the commission of first-degree murder. And all the evidence at trial clearly pointed to this defendant being the principal in the commission of the crime.
So you're essentially saying it should never have gone to the jury on the joint venture theory?
Absolutely. I'm saying that. There was an objection before the jury instructions were given. There was an objection after the jury instructions were given.
Okay, but the way that the case did go to the jury with the special verdict slip, why isn't this case governed by Rendon Alvarez, which was a case that said that where the jury left did not find the defendant guilty on one theory, he couldn't be retried on that theory? Wouldn't that solve your problem?
Well, I don't believe he can be retried on the
if we
principal
adopt
theory.
that would end the case.
That's right. That's right.
Yeah, okay.
That's right.
Okay.
Matter of fact, it's even perhaps a little more involved than that. Judge Hillman gave instructions saying you can only check one box or put a check mark, and you must be unanimous.
That instruction may have been wrong. May have been wrong.
That's correct. And there certainly was no objection from the Commonwealth on that either.
Why do you say that the only evidence in this case was that your client was the shooter?
Well,
was a shot, right? Yes.
Right. Yes. The reason I say that is the Commonwealth put up a cooperating witness who got up there and said, "That's the man who fired one shot. No one else in the car fired the shot," and that was their entire presentation.
But somebody else, the woman in the car behind, said the front seat passenger, albeit with a white jacket.
Right.
Well, but you can take parts and parts if you want. She said someone in the front passenger seat was the one who fired the gun. And the defendant said that he was in the front passenger seat.
There is conflicting testimony, but no rational juror looking at this after given all the evidence that went into in this case would ever have convicted him of joint venture.
But if he took out the gun from his pocket,
gave it to someone
else.
While
they're having a fight with the man in the car next to him.
There's no evidence of that in the record. I mean, you can't.
Somebody said that he took out the gun and passed it.
Or something like that.
I'm sorry, Judge.
Wasn't there a testimony about a sock being passed back and forth?
Yes, after the shooting.
Yeah.
After the shooting, there wasn't testimony. What it was in the defendant's statement. The defendant's statement said that he saw a sock going from Lopez, the Commonwealth's cooperating witness, to the driver. There is that testimony. That was in his statement.
All right. So what does your client say happened in his statement?
He says he didn't do it.
All right. He was in the car.
Oh, he's in the car. No question, he was in the car.
And what did he see?
He didn't see who shot anybody.
Did he see someone taking with a gun?
No.
He saw nothing.
No.
Okay. So that's your client says he's sitting where in the car?
Just 1 minute. There is testimony, at least according to the Commonwealth's brief. While this argument, the argument with the victim, was happening, Mr. Lopez saw the defendant reach into his waistband and pull out a gun that was covered in a sock.
Right. That's what Mr. Lopez says.
Okay. So he saw it come out in the sock before the shooting, not after the shooting, as the defendant says.
But the question was about the sock being passed from the back to the front of the car, and that was after the shooting.
Well, it surely wasn't in the sock while it was being used to shoot.
Apparently it was. Apparently that was, and I don't want to go outside the record, but I believe that's the thrust of it, to catch the shells from falling out.
Let me ask you this. If there is evidence, I know you think there isn't, well, maybe you think there is. If there is sufficient evidence that your client was the principal,
right?
Okay.
The shooter,
and
if believed.
If believed, right. And the law, I believe, is that a principal is part of the joint venture to begin with.
If there's a joint venture, the principal is part of the joint venture, I think.
yes,
Right.
yes. I mean, a principal can also be
A joint
is a
venture.
joint venturer.
Well, he's certainly, the principal's part of it.
That's
Uh,
true.
Logically, he would be.
All right.
But the case law is very clear that if the and it's the Green case, which is cited in my brief, if the man is convicted, if the individual is convicted as a joint venture, there has to be evidence that someone else was the principal.
Or no, that someone else was, that there was a joint venture, that there was someone else.
Right.
Yes.
But that there was that someone else shot was the shooter.
No, I don't think that's
And
right.
I believe that's the Green case, which is astonishingly similar to this case. In that case, you had
Mr. Maidman, what about the cases where you don't have an eyewitness? I mean, this is not an unusual case. The hypothetical I'm about to give you, there are 4 people go into a room, the shots are fired, 4 people run out of the room, and, there's a dead, somebody's been shot and killed in the room. Right? You don't have to say which one is the principal. You can have a conviction of all 4 on joint venture.
right.
Correct.
Correct. But
So here we know that there were 4 people in the car.
right.
That we know that somebody from in the car shot and killed somebody.
Yes.
Correct.
Right.
It
But-
might be that the Commonwealth couldn't show. You're saying in this case the Commonwealth could and did show
That's
that it
right.
was your client.
Correct.
But let's assume that they hadn't been able to show it. There were conflicting things about front, back, which passenger side, and so on, which is not unusual.
Right.
You can have a conviction of joint venture.
Right. But in this case, that's correct. But in this case, no rational juror would have concluded anything other than the defendant was the shooter, because there really was no other evidence that the defendant was anything but the shooter.
But I guess the problem I'm having is that I thought, but I will acknowledge to you that the law is not exactly clear in this whole area. But
Right.
I thought that, as a matter of logic, if nothing else, that if one was a principal, one was by definition part of the joint venture. Let me just finish it, and then you can. And therefore, if there is sufficient evidence for a jury to find a defendant guilty as a principal, the fact that they might have checked off a joint venture box doesn't really matter.
Well, I think the response to that is that in Massachusetts, in order to be convicted under a theory of joint venture, under the Bianco case, there's 3 criteria. And yes, he was present in the car. I don't think there's any dispute about that. But the 2 other elements of the theory are completely missing.
I agree with you to this extent. If there's not evidence that the person is the principal, then you're right. You have to prove that he's present, he in some way assists, and the other things. But if he is the shooter, and there are other people in the car, by definition, he is part of that joint venture.
My only response would be, I think that would change the law in Massachusetts. You cannot be the principal and the joint venturer at the same time.
Yes, you can, I think.
Logically, how does that make sense? I mean, if a joint venture is a venture between people who are engaged in a single activity or an activity designed to a single purpose, and the shooter, if there are people engaged, the shooter is one of them.
Right.
But by logic.
Well, that also assumes that other people in the car were part of the joint venture.
Yeah,
And then they also had the same mental state,
Okay,
mental
yes,
state
you
and
have
everything
to
else.
prove that there is a venture, yes.
And there's no evidence of that in this case either.
Well, that's why
Okay.
when Justice Spotswood gave it the first time around, I said, assuming that you can prove there was a joint venture, and you're saying there's no evidence of joint venture.
Right. That's what Mr. Lopez gets up and says, that's the guy who did it in one shot.
But apart from that, there's no evidence that another hypothetical, not this case, some evidence that 4 people say, let's go get him,
Right.
right? And they pile into a car. This is also not an unfamiliar fact pattern. They pile into a car, they go, and there's no question that A is the shooter, correct?
Right.
In those circumstances, would you agree with me that if the jury, if you have a verdict form like the one here, principal joint venture, if the jury tick off joint venture, that's okay? If there was clearly evidence of a joint venture.
And the defendant wasn't the shooter.
Was the shooter. I'll make the case even stronger. 4 people say, let's go get him, and there's evidence that all 4 packed a gun, stuck it in their
Right.
belt, got in the car, went. There's only one shot, and it happens to be your client, right? No question joint venture. No question.
I believed he would be the principal in that, and the other people would be convicted of the joint venture. I mean, I understand. I see where you're coming from, but I don't think that's at least my understanding of the law in Massachusetts. You can't be. It's sort of like in receiving stolen goods. You can't be the thief and the receiver at the same time.
Well,
Can we talk about the facts for a bit?
Sure.
Just prior to the shooting, wasn't there some back and forth between these 2 cars? Wasn't it described by one witness as if the victim was pleading with the people in the other car, and that they followed the car and caught up with it again, drove very close to it? I'm just wondering if there aren't enough facts there to say there was a joint
Well,
venture.
let me address that.
That's what the Commonwealth argues.
That's what they argued a subset of that when they asked for the joint venture instruction. They said they were all in the car, they were all arguing, therefore there's a joint venture. They did, and they made that argument twice.
And the car
That's not clear, Your Honor. I don't
follows, chases, doesn't it catch up with him? And
that's conflicting as well. One witness said that one version of this incident, and the victim is in the right lane. One witness says the victim drove forward and then went ahead of the defendant's car into the left lane. This is in a 4-lane street in Worcester. I think that's in the record. Another witness, 2 witnesses say that both cars went straight ahead. One or 2 witnesses say that Mr. Rivera, the victim, swerved into the defendant's car. Another version of this is that the cars came close together. So the testimony is all over the map. That's my point on this. The thrust of the Commonwealth's argument, and there was one. The Commonwealth at one point in their closing argument, they said something along the lines of, "Well, the defendant's car maneuvered in close, so they get the killing shot in." I think that's a stretch. I think what really happened. Well, I wasn't there, and I don't know, and we have to rely on the record, obviously. But there's no question the cars came close together. That's about as far as I can address those facts for you.
Can I go back again to the basic structure of this? We have a car, we have 4 people in it. Where does your client say he was in his statement to the police? Did he testify as well?
No,
just
he
gave a
never.
statement to the police.
He did not testify.
Where did he say he was?
Let me. I want to make sure I say this right.
Said in the front seat.
I think he said he was in the front seat. That's right.
So front passenger seat
That's
is
right.
your client. And,
Right.
And who's the driver?
That's Mr. Tony. That's undisputed.
Okay. And who's in the back seat?
Mr. Lopez is in the back driver's seat.
Driver's seat. And who's in the back passenger seat?
That's disputed.
That's
unclear.
Faison, unless Faison is either in the front
Right,
seat or
he's
back
either in
seat,
the front or the
depending on who you
back.
believe.
That's
Yeah.
correct. That's
Okay.
correct.
And
So
the shot clearly came out of the passenger side of the car.
That is yes, that's the evidence. Although
Front or back? Any evidence which it was?
That's unclear. I don't think that's clear. One other than Mr. Lopez saying I saw him do it. One reading of the evidence, depending on where the cars were, is that someone stuck their hand out, and this is I think fair reading. I think this may even been one of the closing arguments. One reading of it is that someone on the passenger side stuck their hand out of the car and then had to shoot over the top of the car or shoot over the front of the windshield.
well, wait a minute. Also, wasn't there also testimony that it was an arm in a white windbreaker?
Right.
Yes.
And wasn't that a critical
Right,
fact?
and the defendant wasn't wearing a white windbreaker.
Right.
But he was wearing a white shirt, wasn't he wearing a white
No, he was wearing a
jumpsuit
blue
shirt?
shirt.
Blue shirt and shorts.
Oh, okay, all right.
Blue shirt.
All right, so
but
here's evidence that someone else in the car did the shooting, okay? Because someone said the person who did the shooting stuck their hand out, white windbreaker, and fired.
But that's not the, that one statement would not be sufficient evidence for a jury to rationally conclude that the defendant was anything other than the principal, given the state of the evidence in the case.
But I don't understand. But that's not him. He doesn't have a white windbreaker on. Someone else in the car has a white windbreaker on. I'm just saying, there's evidence before the jury. They could have found that the person with the white windbreaker did the shooting. Your client was in the car. Your client passed the gun to the shooter. I mean, wasn't there evidence from which they could draw that inference?
I don't know. I don't believe there's any evidence. I mean, I read that in the Commonwealth's brief. That's the first time that I've ever, my recollection anyway, is that issue ever, that version of this case ever came up.
I have to say, from the briefs, I am very confused about the evidence in this case.
Can I ask you this question? The statement of your client.
Yes.
He's in the front.
Yes.
He sees at some point, he doesn't see it shot, but he does see this sock go from front to back or back to front?
Back to front.
Back to front.
Back to front.
So.
And after? You say after?
I say after.
Okay, but here's my question. Take that statement. Isn't that evidence that, forget him, that the other three are part of a joint venture?
The other three are part of
They're doing this fighting and they're moving
He's
in.
certainly denying that he participated in it.
I'm saying
But-
yeah, forget him. The other three.
But is that the question that you have to ask yourself from a constitutional standpoint? Is that sufficient evidence, viewed in the light most favorable to the Commonwealth? Is that sufficient evidence for a jury to find him guilty of a joint venture? And I would suggest no, especially given that the entire case, literally the entire case was, this is the guy who shot him.
Right. I was really trying to address, I think, the Chief Justice's question about, was there, assuming he was the principal, was there evidence of a joint venture? Because you said no, and I'm just saying from his own statement, there is some evidence that the other three were engaged in a joint venture.
There is that. The evidence is what the evidence is. I mean, I don't deny that. But again, the real question is, and this is, I think sometimes sometimes I overlook it, but sometimes overlook that it's the issue is not just is there any statement in the record, is there constitutionally sufficient evidence for a jury to rationally find that the government made its case, and in terms of the Winship case.
Obviously, the jury can pick and choose. You've got a lot of witnesses here with slightly conflicting stories, all of whom say, obviously, the shot came out of the car, in which your client was a passenger.
But the issue you raise is an interesting one, because if you literally read the cases, and now I'm turning to the Commonwealth's brief, if you take Freeman, which is a very well-established one, but you have to look at the facts in which this came up. The description of joint venture often comes up when the defense is there was insufficient evidence to show that I was part of a joint venture, and where there is not necessarily, and usually isn't, a claim that this person was the principal. And so you get statements like, one who aids command, joint venture is one who aids commands, counsel, encourages commission of a crime while sharing with the principal, yakety yak yak yak, or present at the scene of the crime with the knowledge that another intends to commit a crime. I mean, that's the classic joint venture.
That's the Bianco case. Not only a classic, but there's no. I would go so far as to say there's no evidence other than the fact that one of the witnesses in the car behind saw an argument between the two cars. There's no evidence that this defendant had the shared intent to do anything with anybody else in the car. He was in the car.
He was just the principal.
And one thing that's very clear in the law, law of principles and the laws of parties, is that mere presence is not enough to convict you. You have to be in on the crime.
No, I understand. And you're here saying he did it, it was him, and there was nobody else engaged with the venture.
That was the Commonwealth's case. I don't know how to say it any differently.
Well, if we should agree with you that there wasn't sufficient evidence for joint venture, then we reach what to me is the more difficult question, the legal question of what that means here, the fact that the jury did not check the second box. Of course, they may have been wrongly instructed by the judge that they could only instruct one box. If they were wrongly instructed, then what do you say? How does that affect?
The quick answer is that
For once
you don't
the
have
wrong-
to decide that today.
No, but if we decide that there is enough evidence, yes, I agree with you. We don't have to decide it. If we decide there is not enough evidence on joint venture, that would end it. But if we decide, no, or maybe the reverse, if we decide with you that there's not enough evidence on
Of a joint venture.
of a joint venture, then we get to this other question.
Good.
of-
Can it be retried?
Right, and what does that mean when the judge instructed incorrectly, if he did, that you can only check off one box? Then what does that mean? That would mean that the jury didn't know they could check off the principal, and it would not be an implied acquittal under Carlino, I think.
I think it would be, let me just answer. I think it would be the implied acquittal, and in particular because the judge got up there and gave the additional instructions.
What additional? He gave
He
the
got,
instructions.
it's on
you only
page,
check one.
he got up there and said, you can only check one box,
Right.
and you have to be unanimous.
Right. Maybe he made two mistakes.
Maybe.
Maybe.
I don't
And
know. But again, we
yeah,
hold
well,
that against
have
the
to-
defendant. I mean, the jury,
Okay, we have to struggle with that if we adopt your theory.
I guess let me close by saying I rely on my brief for the other two issues.
Thank you, Mr. Maitland.
Thank you.
Good morning, Ms. King. Maybe you could help five justices
I certainly hope I can, Your
understand
Honor.
Evidence.
Michelle King, Assistant District Attorney for the Commonwealth, Your Honors. Obviously, this is going to come down to a factual issue. I think,
But I have a question for you, and if you aren't familiar with the case, that's fair enough, and I don't mean to make this a test. I have more items at my disposal than you, but after the defendant mentioned the case of Commonwealth versus Green, I looked that case up, and that case, which was written by Chief Justice Liaco, says apparently what the defendant says. The Commonwealth failed to offer evidence to raise the issue or from which a rational jury could find beyond a reasonable doubt that the defendant was a joint venturer. The Commonwealth needed to present evidence that there was a principal other than the defendant who committed the shooting. Can you rebut that? What do you say?
I can, Your Honor, and I do agree with that statement of the law. I believe that if the Commonwealth only presented evidence in this case that Mr. Zanetti was the principal and he were convicted as a joint venture, that would be an error. I would distinguish, however, the Green case. The facts of that case are significantly different from this case in that the Green case, the only evidence that was presented was that Mr. Green could have been the shooter. There was evidence from a witness who was in the car with the victim that the shot came from the passenger of that car, that she previously knew the passenger of that car, and she identified him as the only possible shooter. There was another witness in that case that said that the shot came specifically from the passenger side of that car, and there were only two people in the car. In this case,
So in that case, you've got the absolute opposite.
precisely, there's only one possible shooter in that car, and that was Mr. Green.
And no evidence of a joint venture between the driver and the passenger?
None whatsoever in that case,
What if
Your
here
Honor.
we say there was insufficient evidence for a joint venture?
I'm sorry, I didn't hear the first part. Your
What
Honor.
if in this case we say there was insufficient evidence of a joint venture, and that the only sufficient evidence to go to the jury on was as a principal?
Well, supposing that's what you're going to say, Your Honor, if that is in
At
fact what you're
least a
going to say,
possibility.
that would get me to my second argument of the retrial, but I suggest to you that there is sufficient evidence
Okay,
of a
so
joint venture.
let's just focus just on the joint venture. So you
Yes.
can certainly include what the defendant said, but the three other people, where's the joint venture?
If you have, you look at the testimony, admittedly it is quite confusing in this case. You have the testimony of Ms. Dusso, who was behind the victim's car. She testified that all of the occupants of the defendant's car, all four of them, were arguing with Mr. Rivera, that Mr. Rivera was seen somehow using his hands to plead his case. So you have the involvement of all four of the occupants of that car arguing back and forth. You have the fact that...
I don't mean to interrupt you.
Sure.
So at this point, both cars are stopped and her car is stopped, correct?
Yes.
Okay, keep going.
Her car is directly behind the
Behind.
victim's car, and that car is in the
And
right-hand
she's saying,
lane.
I can see the victim is here, and I can see that all four people are arguing.
Yes, she can also see the two back occupants. The two occupants are in the back seat of the car, looking around back and forth behind them together, sort of in concert, looking back and forth. You have the testimony that from the other passenger in that car, Ms. Mazzucchelli, I believe her last name is pronounced.
This is a passenger in Ms. Dusso's car?
Correct.
Okay.
She says they're all sitting at the light. Everybody sort of agrees they're all sitting at the light. The victim's car takes off first and starts to sort of drift into the left-hand lane. Her testimony is that the defendant's car went very close to the victim's car, about 8 inches away, such that it was starting to go into the oncoming traffic lane and was next to it. So
It's still on the left, though. It's still on the left of the victim's car.
Still on the left of the victim's car. So you have the victim's car sliding over to the left, and now you have the defendant's car going over around it into the oncoming lane. So I think the evidence would suggest that the driver is pulling up next to the victim's car so that someone in the car can take a shot.
Okay, but
And I
how
think
does
that's
that
a
help?
reasonable inference.
Right, let's go. All right, next piece
Go
of
ahead.
evidence.
So
Okay,
Then
so
what?
how does that connect the defendant to a
Right.
joint venture?
the defendant's in the car. He's arguing back and forth with
Okay, but let's go on to the next step.
okay, so the next step is then the shot?
Is that it? Is the next step the
The
shot?
next step is the shot. You have the passenger in Ms. Dusso's car saying only that she heard a shot. She didn't see who fired the shot. You have Ms. Dusso saying that the front passenger person in the defendant's car fired 2 shots. Now, her testimony was a little confusing in that she had him doing this. She also had...
So this is the driver of the car?
This is the front passenger of the car, the gentleman with the white windbreaker.
But isn't by her testimony, isn't the victim's car to the right of the...
The victim's car is now at this point to the right. So it's 2 shots like this.
What?
Admittedly, the
But that's
testimony
what I
is
don't
incredibly
understand.
conflicting.
That
I think
doesn't
that
make
you...
sense.
Yeah, but forget
Correct,
the
it doesn't.
All you have of the defendant doing anything is that he's seen arguing, if that. If Joe
Well,
wants to
no,
leave
you
it,
have
with
Mr.
the-
Lopez's testimony
Okay,
that it's the
saying-
defendant who introduced the gun to the fracas. He saw Mr. Zanetti pull the gun from his waistband. It was covered in a sock.
Whose testimony is this now?
This is Mr. Lopez's testimony
In the car.
in the car. That the
Who's a backseat passenger behind the driver, correct?
under one of the items of testimony. There's no doubt that he was in the back seat. The only question is whether or not he was in the back driver's spot or
And
the
he
back
can see somebody pulling it from the...
passenger. He sees Mr. Zanetti pull the gun from his waistband. It's covered in a sock. So you have his testimony that it was Mr. Zanetti who introduced
The
the
gun.
gun to the situation. You have Mr. Zanetti's testimony that says...
Or
that-
statement.
statement that he was seated in the front passenger seat, that it was Mr. Lopez who was seated behind him in the back passenger seat. Mr. Zanetti says that as this argument was going on, he saw the victim reach for a gun, and he yelled, "He's got a gun." Mr. Zanetti ducks down. He hears a pow. He checks himself to make sure he's not shot. And then at that point, he sees Mr. Lopez pass this gun that's inside a sock to the driver, who's Mr. Tony. Mr. Tony, according to Mr. Zanetti, then hands him the gun and says, "You go get rid of it."
Hands the gun to Zanetti.
Hands the gun to Zanetti and says, "You
You
go
go.
get rid of it."
So that's Mr. Zanetti's story.
That's Mr. Zanetti's story.
And Mr. Zanetti then says he gets rid of the gun.
Gets rid of the gun, which was never recovered.
Okay, if the, we would have to say, to affirm the conviction, that the defendant pulled the gun out from his waist for it to be used to shoot the victim. He could have pulled it out from his waist just because he saw an argument going on and he wanted to have the gun for self-defense. He didn't like what was happening, and if anything escalated, he wanted the gun for self-defense.
He could have, but he still was the one who initiated the pulling of the gun out of his waistband, so that certainly includes him as far as a joint venture goes. He's the one who introduced a gun to the situation. So I mean, it's clear that there's conflicting testimony, but it's also clear that where there's conflicting testimony and conflicting inferences can be drawn, that it's properly for the jury to determine where the truth lies.
Ms. King, yes, you introduced the gun, and I think that was the import of Justice Cowen's questions, but what evidence is there that jointly they intended to commit a crime?
Well, I think initially it's the fact that they're all in the car together, they're all arguing back and forth with the victim. You then
I can't tell you how many times I have seen two people, two cars, one rolled down, they start shouting, then the front person rolls down, starts shouting, and then the person in the back. I mean, I don't see lots of crimes committed, but I see a lot of shouting and people rolling down windows and starting to scream at each other. And they're usually followed up by a few physical gestures.
Absolutely, Your Honor.
Haven't ever seen anybody pull a gun out, fortunately, but I have to say I'm always worried that one of them is going to do that.
Absolutely. And I think here, though, you have the added elements of the driver taking the car. At least Mr. Lopez also testified that when the shot was taken, the cars were approximately 8 inches apart. They were very close. It's also undisputed that it was the victim's car that drove off first. So
no, I understand that. So I'm just trying to think. So the drivers
Catching up.
were sort of teed off, and I've also, I have to say, more than once seen somebody, jump ahead or push over, and as they go past again, do a physical gesture, and you think this is dangerous driving.
well, dangerous driving or something else is about to happen, and I think that's a reality in our world now, that it does, in fact, frequently escalate to something
But again,
more.
I'm looking for the joint venture to commit a crime.
Well, again, I think if you believe Mr. Lopez's testimony, the fact that Mr. Zanetti was the one who pulled the gun out of his waistband, that's in
No,
potential.
and Mr. Maidman would say, no question. That's my client. He's the gun he shot.
Well,
but
of course, that's his theory, but it's not just the Commonwealth's theory or the defendant's theory. It's what the evidence can reasonably show and what can reasonably be inferred. And I think there's a reasonable inference that Mr. Zanetti pulled the gun from his waistband and handed it to someone else who was the shooter. And Mr. Zanetti's own statement was that someone else pulled the trigger. So I think it's a reasonable inference when you put all of these conflicting testimonies and statements together that this was a joint venture.
Or certainly that the jury could have found that it was a joint
Certainly
venture.
that in the light most favorable to the Commonwealth, that it was properly before the jury.
What do we
By
do
the way,
about
was a gun ever found in the victim's car?
I believe, no, there was not a gun found. I believe actually what he was reaching for was a cell phone. There was a cell phone in his hand when everybody got to him. So there was no gun.
If we conclude that you're right, that there's enough evidence for joint venture, that would end the case.
Yes,
Then
it
the
would.
jury would properly have convicted of joint venture, even though wrongly instructed, or even if wrongly instructed.
Correct.
What do you say about the wrong instruction? What's the effect of that if we conclude there's not enough for a joint venture?
What I say to that, Your Honor, is that this case is significantly different from the case that you spoke of earlier, the Rendon-Alvarez case. In this case, similar to the Rendon case, the judge did instruct them that they could only check one box. The problem in this case is the trial judge told them that they had to be unanimous as to their theories under first or second degree murder, which would mean they had to be unanimous as to whether or not the defendant was a principal or a joint venture. And that's simply a misstatement of the law. If you look at the case of the Santos case, it's very clear that the defendant, the jury does not have to find, doesn't have to be unanimous with regard to a principal or a joint venture. So the problem here is that by instructing the jurors that they did need to be unanimous, the only thing that we can ascertain from their verdict is that they were not unanimous that the defendant was the principal. They could have been deadlocked, for example, as to whether or not the defendant was the principal, but unanimous as to whether or not he was the joint venturer. So the problem is we can't have implied acquittal on on the principal here
Let me
because
ask
of the
you this.
improper instruction.
With respect to the instructions as a whole, would the fair inference of the jury have been that you can't be both?
I think the fair inference correct would be that you could not be
Because
both
the
the
judge
principal.
explicitly said
Yes.
you may only check one box.
Right. I think it was fairly clear that the jury needed to either find a principal or a joint venturer, not both.
So
That was
if
fairly
that's the
clear.
case, and they unanimously decide that he's a joint venturer, I guess I don't see why that isn't an implied acquittal.
Because they didn't need to pick
Because
either.
they were told they could only check one box, so once they checked the one box joint venture, they couldn't under the judge's instructions.
No, but I'm just
Check this
asking
one
the
even
question
if they
whether,
thought they were.
forget the checking the box, just
Well,
that the law is you can't be both. So if they all
Oh.
agree that he's the joint venturer, then it seems to me implicit in that is that they're agreeing that he isn't a principal.
If the law is that you can't be both.
If that was what they were instructed, that's what I'm asking.
I think the way the jury was instructed, they could have simply been deadlocked on a principal and just decided not to do any further deliberations on that and moved on to the joint venture, and they did come to unanimous verdict on that. I think the problem is that we can't imply that they were unanimous as to the defendant being not guilty on the principal.
As long as the law is that you can be convicted of both joint venture and principal.
I'm not sure I understand your question, Your Honor.
That's all right.
Do you think the law is that you can be convicted of both joint venture and principal?
I think what we spoke of earlier, the Green case, makes it clear that you need to be one or the other, that you can't be
But we
at
have
the
a
same
case
time
of-
the principal and the joint venturer.
But we have a case.
We have language
we
in
have language
cases
in
saying,
I can read you from cases, for instance,
I don't want to argue against my own case, Your
I
Honor,
don't.
certainly.
No, but I
but-
mean,
But it's a
that's-
very interesting question,
yeah.
because as I say, most of the cases come up where it is clear that there was a shooting. It is, the Commonwealth cannot establish beyond a reasonable doubt that it was this person. As I said, the classic is the four people going into a room, no eyewitnesses, nobody gives a statement.
Well, that, Your Honor, is the Williams case where
Right.
two gentlemen went into the building, somebody shot them, we don't know who, and
They both came out.
they both came out and he was convicted as a joint venture, and that's fine.
That's absolutely fine, but the question is, here, and Mr. Maidman has made a very interesting, at least, argument that, you know, the evidence, that the whole thrust of the case that he was a principal, and so in any case, if the jury had been correctly instructed that they could tick off both boxes, can you do that, and can somebody be convicted as a principal and a joint venture?
Well, again, I think there certainly was plenty of evidence here that the defendant was the principal. There was also evidence that he was not the principal. So I would, at least in that part, disagree with defendant's counsel that all of the evidence pointed only to him as the shooter. I think that's not a fair reading of the evidence, Your Honor.
What he said was, no reasonable juror could reasonably infer, I think was his, I mean,
I think that's what he got
Mr.
to.
Maidman is very careful about representations he
I
makes to this
agree with
court.
you, Your Honor. I think that was a fair statement of what he said. I think, though, and again, I don't want to talk myself out of my own case, but I think the majority of the joint venture law talks about another person being the shooter if you're the joint venturer. So I do think that being convicted of the principal and the joint venturer is not possible under the case law. But I'm happy for Your Honors to elucidate that. If there are no further questions, I'd rely on my brief.
Thank you, Mr. Chair.
Thank you.